Ladies and gentlemen, dear friends and colleagues, I welcome you to tonight's event of the Forschungsstelle Provenienzforschung, Kunst- und Kulturgutschutzrecht, the Center of Research for Provenance Research, Art and Cultural Property Law. If I counted correctly, it is the 23rd event in our lecture series, and as so often before, we are today focusing on maybe the most important topic in this area, and that is the restitution of Nazi-looted art. We are approaching this topic today from a comparative perspective, in that we will be looking at recent developments in Germany and the Netherlands in comparative perspectives. And as I said before on other occasions, it is a challenge to understand ourselves in a better way by comparing ourselves with the other. And this is the spirit that we are trying to adopt tonight. I am very proud and pleased to welcome today a special guest in our lecture series, and that is Dr. Tabitha Oost. Tabitha, you are an assistant professor at the University of Amsterdam, and I would really say, and I stick to that what I said before, that you are one of maybe the leading talent and expert in the field in the Netherlands of your generation, and it is a particular pleasure having you here tonight as a dialogue partner. I would also like to welcome a number of personalities and institutions that made it possible to organize this event. First and foremost, I would like to welcome my dear colleagues from the Research Center for Provenance Research, and that is Professor Lucy Wasensteiner and Dr. Florian Schönfuss. It's great that you are here, and I would like to mention on this occasion one of your latest achievements, and that is a very interesting edition of your online journal Transfer. I think the title makes sense to us immediately in the context of our topic. And in one of the latest, if not the latest edition, there is a very insightful interview of yours with the chair and the co-chair of the Dutch Restitution Committee, Toon van Mierlo and Dick Oostinger. And I recommend the audience retrieving this latest edition. It is online open access, and I think it is fair to say that this rather new journal made it right to the top of the relevant journals for provenance research, including interdisciplinary perspectives. Thank you so much for being here. I would also like to thank the Center for Dependency and Slavery Studies that co-hosts this evening, also the Bonn Center for Reconciliation Research. Above all, I would like to thank each and every single person in this room, because we are operating on very difficult conditions tonight. You may have noticed it, everyone in the video room, there is a current heat wave in Europe, and this heat wave also struck Bonn, which is not surprising to everyone who knows Bonn. It is the first place to be on the top of the temperature scale, and that is also what happens these days. The president of the university recommended considering staying at home. I'm particularly grateful to you that you did not follow this recommendation, and rather that you are here tonight. Thank you very much for that. I would also like to thank everyone in the video room. We have a huge rate of registrations, more than 100 from very different nations, regions of the world. We have guests from Hong Kong, China, of course, from the United States of America, Israel, Germany, other European countries, so that we are a kind of global visible, not invisible. There's a lot of talk about global invisible colleges. We are having here a visible global college, and I think this is the best setting to approach the topic. Last, but by no means least, I would like to welcome those amongst you, the many of you, who suffered from the Holocaust. It is you and your voices that we wish to hear also in the discussion later on, in general, to embark on a meaningful dialogue how to respond to the needs and expectations to cope with the Holocaust and its aftermath. And this is maybe the main point and the spirit that in which we are organizing this event. That being said, without any further ado, I hand over to my dear colleague Tabitha for a first round of presentations, 20 or so minutes, with certain points and perspectives on the restitution practice process in the Netherlands. I will follow up with another 20 or so minutes with some comparative points, and then we'll open the floor for discussion. We are inviting you warmly after the two presentations to raise your voice, pose your questions, and participate in the discussions. Thank you very much. Without any further ado, the floor is yours after I have changed the presentation, which will take 1 or 2 minutes.
Kan je helemaal niet zien?
I don't know.
Yes. Okay. Hello, everyone. Good evening. Thank you, Matthias, for these words of praise, which I received twice. So now I have to really meet the standard that you ascribed me this evening. I'm just going to start. Let me see. I need to multitask here because I have to speak from one screen and operate the other. So if something goes wrong, please raise your hands and then we'll fix it. Okay, as most of you likely know, especially the regular attendees of Professor Weller's Bond Talks, the Dutch restitution policy underwent significant changes in 2021 following the recommendations of the Constant Committee. A new establishing degree has been in place since then, and several recommendations have been issued under the new assessment framework. A further development concerns the recent report on the future of so-called hairless Jewish art. Things have certainly been moving in Germany as well. Professor Weller's report on strengthening the advisory commission has ultimately led to its dissolution and the establishment of the new German arbitration court, which has also been given a new substantive and procedural assessment framework. Although the procedural side of things is highly relevant, the time available today does not allow us to explore this during our talk. But we welcome questions on this in the discussion that follows. I will now turn to the current Dutch situation with one word of caution. As Professor Weller already mentioned, a full treatment of either the Dutch or the German framework is not feasible in the time available. So we have therefore chosen to zoom in on selected topics based on two recent recommendations of the Dutch Restitutions Committee to show how the current framework in the Netherlands operates in practice. Matthias, as he said, will then offer some reflections on how comparable issues may be approached in the German context. And after our presentations, we will, as said, open the floor for discussion, and we welcome you all to participate. Now let's see. As a start, I would like to briefly touch upon the key findings of the Constant report as a development and changes that we are discussing today have been shaped by this report. First and foremost, the Constant Committee made a strong statement about the goal of the Dutch restitution policy. At its core, it is about recognition of the grave injustices committed during the Nazi regime. This connects directly to one of the central findings of my PhD research, that is a paradigm shift in how we deal with Nazi-related injustices, from a strict legal model to one infused by the victim's perspective. This shift, however, creates a predicament for restitution committees on Nazi-looted art. Restitution came to mean more than the strict legal meaning of restoring the situation ex ante. It gained a broader significance as an act of recognition. But belonging to a victim group does not automatically entitle one to restitution. A substantive assessment remains necessary. Ownership must be established, and the nature of the loss must also be assessed. And due to the passage of time, that is far from straightforward. The central question that the doctrinal debate has grappled with still remains. What is relevant to such an assessment and what is not? The Dutch restitution policy came under increasing criticism in the years following its initial phase, where it received praise for its low-threshold, claimant-facilitating approach, for one, by providing for in-house provenance research in the reassessment of claims. Part of the critique related to a substantive choice in the policy, the introduction of a weighing of interest test, which allowed the interest of the current owner to be weighed against those of the former owner. This criticism reached a peak after the 2018 Kandinsky case, after the claimant's interest was outweighed by that of the current owner, partly on the ground that the claimant lacked an emotional connection to the work. As you can see, the Constant Committee's recommendations are best understood against this background. Although the Restitution Committee's overall caseload reflects a generally generous approach, the lack of transparency made the committee vulnerable to criticism, regardless of whether every critique was fully justified. Ultimately, and now you can see it on the screen, the Constant Committee, amongst other things, stressed the need to resume provenance research, to actively search for claimants, as well as to establish what it called an unambiguous substantive assessment framework. As mentioned, it is that last point that I will focus on today. Let's see. Before turning to the Restitution Committee's practice, I will briefly address the latest advisory report on hairless Jewish art in the NK collection, which is a collection comprised of cultural objects taken from their pre-war owners during the Nazi regime, covered by the Allies and transferred back to the Netherlands to be returned to their rightful owners. It remains in Dutch state hands to this day. The advisory committee responsible for the advice was established by the Central Jewish Organization in close consultation with the Minister of Education, Culture and Science, in anticipation that even intensified provenance research will, for a significant group of objects, fail to identify original owners or their legal successors. Its central recommendation is to transfer management of the collection, in Dutch a beheersoverdracht, to an independent foundation representing the Jewish community. This is conceived as more than administration. By giving the Jewish community authority over how the collection is deployed, more objects are expected to be identified and restituted, making it both a symbolic act of recognition and a practical tool for advancing restitution. Although I can only underline the importance of involving the Jewish community in view of the NK collection and its history and commend these recommendations, I want to flag one critical point that I also make in a forthcoming article in a Dutch private law journal. The question of whether the Dutch state is the owner of the NK collection or merely its holder is deliberately avoided in this advice, as you can see with these quotes, apparently steered by the ministry itself. And in my view, it is internally contradictory to assert that ownership will eventually pass to the Jewish community while refusing to take any position on what the current ownership status actually is. The result is an artificial separation between morality and law. Moral authority is acknowledged, but its legal consequence is consciously avoided, rendering concepts like recognition of historical injustices ultimately hollow. A principled position on ownership would have placed the entire arrangement on a far firmer legal foundation. And as far as the question of ownership is concerned, to me it is rather clear. The Dutch state became the legal owner of the NK collection through Article 3, 133, the legal regime enacted by the Crown as part of the post-war system of restoration of rights. Under that article, enemy property on Dutch soil was expropriated in favor of the Dutch state. Since these works were brought back from Nazi-occupied territory, the regime of Article 3 applies, making the Dutch state the legal owner, not merely the holder of the collection. Turning now to the substantive changes in the Netherlands. Following the Constant Committee recommendations, the assessment framework was consolidated into a single document, the Establishing Decree 2021, replacing more than 15 previously governing documents. The weighing of interest test that I discussed briefly earlier was removed, though not entirely. One element was retained, the question of whether the current holder acquired the object in good faith. This, however, can only play a role for non-state-owned works. The Dutch policy distinguishes between state-owned works, the NK collection and the General State collection, and non-state-owned works held by, for example, municipalities, foundations, or private parties. The state will not invoke good faith protection for either category of state-owned works, a position that is now expressly reflected in the Establishing Decree. The committee is to assess good faith acquisition on requests regarding non-state-owned works, and then when highly plausible ownership and sufficiently plausible involuntary loss have been established, a good faith acquisition may also play a role in deciding on a mediatory solution. The Restitution Committee may, however, also decide to restitute regardless of a good faith acquisition. Since the new 2021 decree, however, non-state holders have to date always waived their good faith claims, so I will not dwell further on this point. A new element, so what changed of the Dutch restitution policy, is the introduction of a hardship clause in Section 5 of the appendix to the Establishing Decree, which the Restitution Committee used for the first time in its most recent recommendation. I will discuss that recommendation to illustrate how it operates in practice. I will then reflect on elements of the policy that remained unchanged, drawing on another recent recommendation regarding an art dealership. And I will focus specifically on the distinction between private individuals and art dealerships in assessing loss, involuntary loss. I will close the substantive discussion with some remarks on flight goods category that continues to attract considerable attention in the doctrinal debate. Let's see. Oh, that went wrong. In the first recommendation, in the recommendation regarding Citroen of 17 April of this year, as mentioned, the Restitution Committee assessed the hardship clause for the first time. Before turning to the merits of the case, some background on how this claim came about. This case arose directly from the intensified provenance research into the NK collection. The Cultural Heritage Agency, I'm going too fast. Yeah, see? Identified the potential claimants through provenance research, and following the Constant Committee, proactively contacted them. They subsequently submitted a request for restitution. On the substantive side, that's why I went back to the slide. Let's see. You see two provisions of the appendix to the Establishing Decree that were relevant in this case. The new Section 5 hardship clause, which allows the Restitutions Committee to deviate from the assessment framework in exceptional cases, and Section 2, which reflects an element that remained unchanged, the requirement that the Restitutions Committee establishes highly plausible ownership, either of the original owner or, and I quote, of their legal successor under inheritance law. The Restitutions Committee, shortly after receipt of the request, already observed a lack of plausible standing, as, and I quote, the applicants were in all likelihood not to be regarded as heirs of Abraham Citroen, pursuant to inheritance law, and that for this reason, after taking the request under consideration, the committee would have to advise rejection of the application. The claimants, however, did not want to retract their request, knowing this. The claimants from the beginning of the proceedings, and I quote, urged and implored the Restitutions Committee to apply the hardships clause. They stressed that they saw themselves, and I quote, as the sole moral heirs to their grandparents' estate, as well as the special symbolic and emotional value of the objects, which were concerned plates, to them as a tangible reminder of their grandparents. Moreover, the claimants advanced their view and belief that the plates represent, and I quote, the deprivation of the rights of people for who they are. The committee ultimately rendered a complete advice that indeed resulted in a rejection. The committee found that the claimants had been excluded as heirs by their father's will, made after his remarriage some time after 1994, and concluded that they were therefore not legal successors under inheritance law. It then considers whether the hardship clause could justify departing from this requirement, but found no compelling reason to do so. Invoking the clause would, in the committee's words, infringe on the freedom of a person to determine their own legal successors by will. In my view, this case illustrates the difficulty inherent in the work of these committees, a difficulty that flows directly from the paradigm shift I argued for in my research. It is evident from the recommendation that the Restitutions Committee made genuine efforts to pursue a mediatory solution, including, for example, offering assistance in negotiating with a legal successor, the claimant's father's widow. Nevertheless, the claimant facilitating spirit of the Dutch policy, the proactive search for and approach of the claimants by the Cultural Heritage Agency, may well have raised expectations that ultimately proved unjustified, making a negative outcome harder to explain and communicate. That said, I believe that the committee was right in its assessment, as the will was drawn up long after the end of the Nazi regime. The outcome is also consistent with the rationale behind the deletion of the interest test in the Dutch framework. Just as it is not relevant whether a legal heir has any emotional attachment to an object, also framed as an accidental heir in the doctrinal debate, I do not think we should go down the road of accepting claims of moral heirs and override the law of succession. So, my discussion regarding the Citroen recommendation already revealed that establishing highly plausible ownership is an unchanged requirement that is to be assessed by the Restitutions Committee. The same goes for the requirement of a sufficiently plausible involuntary loss. Both requirements reflect lowered evidentiary standards in view of the passage of time. In my view, illustrative of the claimant facilitating spirit of the paradigm shift, claimants are furthermore supported by the in-house provenance research conducted by the Expertise Center of the NIOD, which the Restitutions Committee consequently assesses. These standards apply in principle equally to another still existing and distinct feature of the Dutch policy, the distinction between private owners and art dealerships. This distinction has two dimensions. First, substantiating a claim concerning an art dealership may require more of a claimant than for a private owner when it comes to establishing highly plausible ownership in terms of the production of proof. Second, and in the wording of the restatement in Article 6, the attribution of loss is also assessed differently for these two categories. The ratio of this difference lies in the very nature of the art trade. An art dealership exists to buy and sell, and its trading stock may, but will certainly not always be the dealer's own property. This distinction is now more clearly reflected in the 2021 assessment framework in relation to the requirement of sufficiently plausible involuntary loss, which now provides for three categories: private individuals, art dealerships, and for the critical slide readers who noticed, a catch-all clause for losses falling outside both categories, which I have not included on this slide. For private individuals, involuntary loss is presumed if the loss occurred in the Netherlands after May 1940, Germany after 30 January 1933, and in Austria after the Anschluss, unless there is express evidence pointing to the contrary. For art dealerships, that presumption does not apply. The first step is to determine whether the object belonged to the art dealer's trading stock or to their private collection. If sufficient indications point to the art dealer's private collection, criterion 3.1, which is included on this slide, applies, meaning that the claimant will benefit from the presumption of involuntary loss and a lower standard of proof. Whether work is attributed to the trading stock of the art dealer, sufficiently plausible involuntary loss needs to be established through indications. And the establishing decree provides a non-exhaustive list in this regard. And you can see a few of them, like a sale by a Nazi-appointed custodian, a verwalter, or a sales price significantly below the market value. To illustrate how this plays out in practice for our dealerships, I will now turn to another recent recommendation. This application was submitted by the great-grandson of a renowned art dealer, Louis Morpuro, a Jewish and art dealer who perished in Auschwitz. The claimant identified the items, all NK works, through the Origins Unknown website, also governed the Dutch Cultural Heritage Agency. This art dealership has been assessed for the third time by the Dutch Restitution Committee. In assessing highly plausible ownership, the committee, as always, investigated ownership itself via indications based on in-house provenance research conducted by the Expertise Center based at Niels. Ultimately, only six of the more than 25 requested objects were returned. Reason for this was that the Restitutions Committee could only establish highly plausible ownership for 3 Chinese vases and a hunting flask. For the remaining objects, highly plausible ownership could not be established because the claimant's drawings and descriptions diverged from the recovered items on points like dimensions, decorations, dating, etc. The applicant's plausible reconstructions and alternative explanations regarding these objects were considered but rejected as speculative, as they weren't supported by or actively contradicted by the archival evidence. Neither the investigation produced this documentation nor the applicant. The assessment of involuntary loss, also based on indications, as is customary in our dealership cases, built on persecution evidence that reflected already in earlier, more Pugo recommendations. From November 1941, a Nazi-appointed administrator sold off trading stock without the owner's consent, precisely the indication included in the non-exhaustive list under criterion 3.2e of the appendix of the establishing decree, which treats administrator sales as an indication of involuntary loss unless the original owner is shown to have fully benefited or later relinquished their rights. The Morpuro case presented no such evidence, and in light of these circumstances, based on this consideration of the Restitution Committee, and despite the evidentiary gap on when the vases were sold, the committee found involuntary loss sufficiently plausible. I will end my talk with some comments on the matter of involuntariness of loss in relation to flight goods. Although the Dutch Restitution Committee hasn't dealt with a case of flight good in the recent years, for comparative reasons, we decided to touch upon the matter because these cases tend to be difficult, again for reasons of attribution, because where should one draw the line? When is a sale still related to the Nazi regime when the sale takes place outside Nazi sphere of rule? Or in other words, how causal should that connection be? On this point, the assessment framework in the Netherlands has not changed either, but merely clarified. The catch-all rule in the Netherlands has now been explicated in the assessment framework, as you can see above. Apart from the category of private individuals and art dealers, other owners may also be eligible for restitution as long as the loss is due to circumstances directly related to the Nazi regime. This originates from the original phrasing of the establishing decree in 2001 in Article 2, which referred to losses due to circumstances directly related to the Nazi regime from the start of the Nazi reign. This is now comprised in a definition on restitution in the establishing decree and needs to be read conjointly with Article 3.3 of the appendix. So in the Netherlands, there is a focus on the nature of the loss. That is, for example, different from the Austrian situation, where the Kunstvergabegesetz is territorially confined to the territory of the German Reich. A sale in Switzerland or the UK falls outside the scope of the Act. This is different in the Netherlands, which is reflected in the Vlersheim binding opinion and the Semmel cases, which concern sales respectively in London and in the Netherlands prior to the occupation. These cases show a holistic approach when it comes to the assessment whether the sale was made due to circumstances because of the Nazi regime. In Vlersheim, the family had been stripped of their livelihood and assets by anti-Jewish measures and forced to pay the Reich flight tax to finance their flight. The committee held that the proceeds of the sale were needed precisely for this purpose, and that the absence of a direct duress at the moment of the sale was irrelevant. Instead, it looked at the persecutory context of the sale as a whole. The same goes for the Semmel case, where the committee pointed to the intense anti-Semitic pressure Semmel faced in Germany from 1933 and onward, combined with his political involvement, which forced him to flee and sell or leave behind his property. The auction in Amsterdam in 1933 was therefore considered directly connected to his flight from the Nazi regime. In both cases, the decisive factor was not where, under what immediate circumstances the sale took place, but whether, absent the Nazi regime, the former owner would ever have disposed of the works at all. I could go on some more about this, but I think I'm now over the 20 minutes. So, Matthias, I think the floor is yours. I'm going to give the floor back to you.
Thank you so much, Tabitha, for this insightful introduction into the recent developments in the Netherlands. I will try to respond in a certain way to focal points of yours, and I selected 4 of them. I'll start directly with the first one. And this is the question whether and to what extent the special collections that we observe in several jurisdictions, like the NK collection in the Netherlands, the MNR collection in France, or the remainders of the central collecting points in Germany, contain objects that are the property of the state, or whether these objects are in some other status. You explained to us that the latest 2026 report on the NK collection and its so-called airless art objects did not take a stand on this question. Well, allow me as an outsider, as an observer and a comparativist, to undertake an attempt to assess the situation in the Netherlands. And of course, you and the experts in the room, in both rooms, in the classroom as well as in the video room, are invited to comment, react, and also to correct whether if I make certain mistakes. First point to note, the objects in the NK collection, these are objects from the external restitution, objects that came from, roughly speaking, the monuments men collecting objects in Germany, on German territory, then occupied territory, transferring objects to the Netherlands. That's the first point to keep in mind. This will be the same for France, but not obviously for Germany. The second point I would like to remind you and ourselves is the Royal Decree 133 of the 20th of October 1944 that relates and focuses on enemy property from Germany in connection with Germany that was expropriated in favor of the Dutch state. And the understanding seems to be that these objects that came after the war towards the Netherlands, towards in the hands of the Dutch state, are covered by this expropriatory measure of the Dutch crown. That is, at least, if I see it correctly, the assessment of the legal status of these objects by at least one recent recommendation of the Dutch Restitution Committee, and that is the case of Franz Oppenheimer from 2019. There is also, as many of you know, your U.S. District Court of California in the famous case of Maral von Saher in 2016 that assessed the legal status of these objects in the same way. Of course, you should consult first and foremost as authority Tabitha Oost, but there may also be people who might prefer having a German description and analysis. And if that is the case, after reading Tabitha Oost, I recommend to you one dissertation that was delivered within our restatement team by Tessa Schiller, who I think made an excellent job in explaining in German language these elements of the Dutch restitution policy and legal situation. And you could find the analysis on this point on pages 40 and the following. The question, of course, is why does the 2026 report not take a stand, a clear and transparent stand on the question, who is the owner of these objects? That remains rather, in my view, opaque. Well, it may be a symbolic question, but if it is a symbolic question, there is no resort to intransparency. It doesn't simply help to cover up the things. You have to address them, and then you have to deal with them. So I would prefer having a clear position on this question. My impression is the one that I explained to you. And let me add at the end of this first point of analysis that, to my mind, it does not really matter who is the owner of these objects. Is it the state or is it the original owner and the state is only the custodian? But the real question is, what is the one who holds the object doing for taking, assuming, complying with moral expectations? And in that regard, it might turn out to be easier if it is the owner who is addressed with moral expectations and claims, because the owner is free to handle its own property as he or she it wishes, which makes things easier because no property issues need to be resolved before taking action. This is exactly the big difference in comparison with France and the in our collection, the Musée National Récupération, museums that hold these objects that came into France as they came into the Netherlands from the external restitution. It is the state of the law in France, if I understand it correctly, that here or there, the state of France, the French Republic, is not considered to be the owner of these objects because there is no comparable instrument as the one that we've seen in the Netherlands, the Decree E133. So the description of the status of these objects is that the state holds a kind of guardianship, trusteeship, Treuhand, we might say in German. That is at least confirmed by one decision by the Conseil d'État in 2014. And of course, there is another, I think, really good dissertation, PhD, that deals with the topic in the French jurisdiction. That is Johannes von Lintig on pages 410 and the following. So let's turn to Germany and the remainders of the central collecting points that are now dealt with by the Kunstverwaltung des Bundes, the art administration of the federal level, so to speak, to offer a kind of convenience translations. These objects do not come from the external restitution, obviously not. And there is one provision in the German Grundgesetz, basic law, that is often misunderstood in this context. And that is Article 134 of the German Basic Law. I present to you the reading in German and translated in English. Das Vermögen des Reiches wird grundsätzlich Bundesvermögen. Translated into English, the Reich's assets will, in principle, become federal property. This has been sometimes misunderstood as a rule that expropriates the original owner, in that an object is transferred from the German Reich to the Federal Republic of Germany. That is a fundamental misunderstanding because the German Reich and the Federal Republic of Germany, these are political entities that are carried by the very same juridical body, which is the German Reich. There is a continuity of the legal person that is the, formally speaking, the owner. The political system has changed dramatically, yes, but the legal person holding the objects as property is the same all over the time. But after the war, as the political system has been changed fundamentally from terrorism, Nazi regime, injustice towards a democratic political order, there was the question, what are we doing with the assets that were held by the German Reich? And that is the answer. These are, as a default rule, transferred to the federal level rather than to the states level. So it is simply a rule that distributes assets that were anyway held as property by the German Reich to either the federal level or the states level. So there is not any transfer of ownership in this rule, and therefore there is no second expropriation by the new state of the Federal Republic of Germany to the detriment of the original owner, as it has sometimes been claimed. If you wish to read more on this point, I will recommend to you another fantastic, I would say, PhD from our team, Karis Hane, pages 204 and following, that explain very clearly this rule. Let me be clear. Of course, the preliminary question that now decides all the real questions is, was an object already the property of the German Reich as it was still carrying the Third Reich, the Nazi regime, as a political order? If so, it remains the property of the legal person that carries the political system, and it is then held as property by the Federal Republic. If it was not the property of the German Reich, then this rule obviously does not apply. And of course, that is the question that we are interested in. That is the question that thorough provenance research would need to resolve, would need to unfold and clarify. And I think it is important to understand this rule in the way I tried to explain it. Second point of comparison, and that is on the question of standing, as we would put it in the legal discourse. And that is, of course, relating to the case of Citroën that was dealt with by Tabitha brilliantly from the Dutch perspective, a very recent case of 17th April 2026. Let me summarize what I understood from this case on the Netherlands restitution framework. Section 2 deals with the ownership requirement and sets a standard of proof of high plausibility. And that includes the ownership requirement, the question, who's the owner? And that is decided according to a principle of the legal heir. So it is the inheritance law, the applicable inheritance law, that decides who is the heir and thereby who is the legitimate claimant today for an object that was taken from the original owner as a result of persecution. Now, as you explained, the Citroën applicants, children in the line of descendants to the original owner, were unfortunately were excluded in the will by the testator in favor of that testator's second wife, the testator being the only surviving son of the original owner. And let me underline once more at this moment that the fate of this family is absolutely terrifying. Many members of the family were murdered in Auschwitz. This is something that we always have to keep in mind. Nevertheless, if the owner delivers a will in that he or she lays down his or her last will to the effect that, unfortunately, his children should not be heirs in favor of another person, I think I have to say, but I submit this to discussion, there is no other way than respecting the free will of the testator, all the more if this last will, this expression of the free will of the testator, apparently was not tainted by threats, by persecution, as opposed to the case of Emma Butke, Dutch, as some people say, but I think we should say Butke. So if we respect the will, the free will of the testator, and if we decide the question of standing according to the applicable inheritance law, there is no other way of deciding, so to speak, that the applicants in the case, the children, are not the ones having standing. Now, you discussed Section 5 as a deviation, as a possibility to deviate from the rules that were laid down or are laid down in the assessment framework. That is always something that can be considered, of course, but I think it is a systematic claim of such rules that escape clauses, hardship clauses, should only be applied in really absolutely atypical circumstances. And I don't think that we really have a case of such absolutely atypical circumstances in this respect. On the contrary, the question, is it the inheritance law as such that decides, or is it some other moral, immaterial consideration that should guide us, has been discussed in other cases as well. I would like to remind you or draw your attention to the also famous case in the on the Kandinsky painting, the Liebenstein case, where there was a lot of discussion on whether there should be a reservation against restitution in case of accidental heirs. An accidental heir would be a person who has no connection family-wise with the original owner, but somehow came into the picture at a later stage, as it was in this case, where there was a factual foster child that was at the end of the day, after the war, adopted by the entitled person. And then there was a discussion, should this exclude the claim for restitution because it is somehow an accidental heir? And the very determined answer, in particular, from the perspective of claimants was, no, there is no way of doing that. An heir is an heir is an heir. And that is a logical perspective if we follow inheritance law, because at the end of the day, we are speaking about the transfer of assets to the one hand or to the other hand. And so there is some sense in proceeding that way. If we do it that way, it would be contradictory to now say, well, now we are resorting to the moral heirs, if that is at all a proper term for describing the situation of the two children. And so I think there was no case, no way of legitimately resorting to this Section 5. Let me close this observation on the Netherlands by underlining that, as far as I could read from the reasoning of the recommendation, that the committee, the Dutch Restitution Committee, undertook a number of attempts to achieve mediatory solutions. Maybe the committee should have considered approaching the heir in this case and include her in the negotiations. This apparently has not happened, which is a surprise if it is correct to me, because now I think, now that the claim is rejected to the detriment of the children, the committee will have to approach the heir anyway, because it is now established that this is a case for restitution. It is established that there is a person who is entitled, who has standing, and that is the heir, that is the second wife of the testator. And so I see no other way than approaching this heir in order to comply with moral expectations to deal with objects in the NK collection. Let's turn to Germany in that respect. Under the new assessment framework that applies as of 1st December 2025. The strange thing there is that there are two provisions. One on the formal entitlement to apply, something we could translate in German terminology with Klagebefugnis, and we see in the rules more or less the same than under the Dutch restitution framework, under the assessment framework, and that is that the applicable inheritance law determines standing. That is absolutely the same approach. And since the German assessment framework excludes at the beginning resorting to any kind of other rules than the ones in the assessment framework, it has to make sure that if there is nevertheless a need to apply rules outside the assessment framework, it has to allow it, so to speak. And in that sense, the assessment framework does allow to resort to property law in order to decide the question, who was at all the original owner to the object? And that is probably to be applied by analogy to the question, who was, in fact, under the applicable inheritance law, the owner, so to speak, the claimant who has standing. All of this is repeated in a certain sense in Article 6, where there is talk about entitlement to just and fair solution, something we in the German discourse would translate by aktiv Legitimation. We see the same rules again. I'm not going further into details here, The only question maybe is, why are there these two sets of rules on more or less the same question? The answer is the following. The assessment framework in Germany also wishes to be applied outside arbitral proceedings, namely in the bilateral negotiations between claimants and current holders. And to make sure that this is possible, there are two of these provisions, one that somehow relates directly to the proceedings within an arbitral proceeding, and another one that deals with the question on a kind of substantive level that would apply outside these proceedings. Last point of comparison in this respect, you may have noticed it already, those who have already looked into the new assessment framework, and you might have asked it yourself, is there an escape clause, a hardship clause like the one in Section 5 of the Dutch assessment framework? And the answer is no, there is no such escape or hardship clause. That would be a matter to debate whether this is the best solution. Maybe that is one question to discuss in the process of the future evaluation of the entire arbitration setup after 3 years or after 10 arbitral rounds. Let me close this second point by a quick look at what the restatement says on the issue. There is a provision that deals with the requirements for the claimant as such, which is, again, on standing. And it says the injured party or their legal successor is entitled to a just and fair solution in accordance with the Washington Principles or their respective national implementations. In the case of entitlement to a claim by virtue of succession, entitlement is determined by the applicable inheritance law. The claimant must prove their asserted status as an heir. So it is our assessment from the comparative perspective as well that it is the applicable inheritance law that tells us who is the heir. Let me draw your attention for a moment to another rule of the restatement, and that is Article 6. That is on the configuration of the just and fair solution. And there we do find an escape clause. For very atypical cases, just and fair solutions may require going beyond the above recommendations. And these above recommendations are all the requirements for the claim and the general rules for configuring the just and fair solution. And I think it is remarkable that this is the assessment of the comparative survey. Maybe that is another argument for thinking about a hardship clause in the German assessment framework as well. Let me lastly draw your attention to subsection 3, litera B. It says the emotional relationship of the injured party or the claimant to the object should not be considered. This is a rule, an assessment that reacts to a number of cases where there were accidental heirs, where there was no connection emotionally, spiritually, if you will, to the family or to the object. And the standpoint very clearly and in a determined way was this should not change anything. And if that is the case, I think it should be relevant for cases like the Citroën case as well. So let me draw the conclusion that the restatement has drawn a quite precise picture in these points that we had a look at. Let's go to the third point of comparison. That is the more Prugo case, as I would pronounce it, but maybe it should be pronounced differently. I don't know exactly. That is a case from October 2025, the claims relating to art dealership. The Netherlands, as we heard, offers a special rule for art dealers, and it says a sale that a Jewish art dealer is considered to be involuntary if there are indications that make involuntary loss of possession sufficiently plausible. So the clear statement of this rule is there is no presumption of a forced sale in this case, but rather a non-exclusive list of indications. Let me go to Germany and to Article 8 that deals with forms of loss and sufficiently close connections. And it says, in the case of legal transactions by dealers, a sufficiently close connection is presumed, which is to be translated by vermutet. So there is a real presumption. However, only if a consideration of all the circumstances does not provide any indication of the orderly continuation of ordinary business transactions. In the discourse about the new assessment framework in Germany, there was the submission that there would be no presumption for art dealer cases. Well, I would not read the assessment framework to that effect, because if we look at the wording, we can see the presumption. But I would describe it as a kind of small presumption, because it only comes into play if there is no indication that there was an orderly continuation of ordinary business transactions. And if that is not the case, the claimant needs to establish by indications whether there was a forced sale or not. What does the restatement say in Article 5 on attribution? You will not find any presumption in the restatement, but rather a non-exclusive list of indications. Why? Because the majority of the jurisdictions does not operate with presumptions. The German former framework did. The current framework does to a certain extent. There are certain presumptions in the Dutch restitution framework, but there is no presumption in France. There is no presumption in the UK. And that is why we did not go so far as to formulate a presumption as a kind of general comparative assessment. Rather, we operated with non-exclusive lists of indication. And there is a list of positive indications for forced sales, indications supporting forced sale. And these are letter A to E in Article 5, subsection 11. Let me add that. It includes a small escape clause in letter E. And then there is a list of negative indications pointing away from attribution of the loss to the Nazi regime. And these are letter F to I in Article 5, subsection 11, again, including a small escape clause. This is backed up by an evidentiary rule in subsection 12 that underlines the relevance of indirect evidence via indicators. That is a general evidentiary tool. There is nothing special in it, but we, of course, need it in a specifically high degree in our cases. And on top of that, the restatement encourages those who are deciding cases to consider establishing presumptions to the extent the deciding body believes it appropriate. Yeah? And at the end of this subsection, there is an overarching reference to Article 4 of the Washington Principles. So let me conclude my tour d'horizon first by skipping my fourth point of comparison. And I see some happy faces when I announce this here. And I wish to go into the discussion with you right now. But of course, this means that I'm skipping maybe the most controversial point, and that is the question of dealing with flight goods. But I would suggest that we should do this in the open discussion with you here in the classroom, as well as with you in the video room. And for doing that, give me 1 or 2 seconds to enable the video room to open micros and to raise their voices. Thank you very much for your kind attention. I invite the audience to think about and maybe even already advance first questions that we can address here in the classroom. Thank you very much for your attention. Okay. The chat is disabled. I think I will not be able to change this at this moment. So I would ask those who are in the video room to open simply the micro according to the list of electronic hands that you can see on the list of participants. So I trust in the self-management and responsibility of the video room without any further curatorial measures on my part, if that is possible. We will see if that works. And we are, of course, looking forward to hear the first voice from the video room. Please don't be shy, but maybe we will start in a classroom first with the first question. Are there any questions? Please, Alfred Fass. Thank you for being here. First question goes to you.
Thank you for having me. A question for both you and Tabitha about the commission, the Restitution Commission in Holland and what is going on in Germany. In Holland, we have if a claim comes in, there is the ECR, which is now managed by the Nuot Institute in the Netherlands, who is doing research about the claim and is making a report. How is the situation in Germany? That's the first part. And the second part is that the ECR was started in 2015 as a result of the Berenschot report, the management report, who took away the research from the Dutch Restitution Committee and put it in an independent body, the NIOT. After 10 years, maybe it's time to research and to have a report. How would you see a report on the ECR about how they work and what their results are in these 10 years of working for the Restitution Committee and doing the research for the claims?
Thank you very much, Alfred. That is a very relevant and rich question that I interpret as having 2 parts. And the first part of it goes to Germany in a certain sense. So I allow myself to try to answer the first part without excluding any further remarks on Germany on your end. But I would hand then over for the second part to you. In Germany, the situation is not optimal in that respect, if you ask me. I think Germany should go for a central unit for provenance research as well, as we see such units in the Netherlands and in particular, and for a long time, and I believe quite successfully in Austria. And I believe that there is some merits in setting up such a central unit. It has maybe task force-like expertise for the questions that are particularly relevant for the arbitral proceedings. There may also be an advantage in terms of neutrality. This is a hot topic. I'm not saying that those who are working on provenance research are not neutral, but it is a question on how it appears to those who raise claims that the provenance research is organized within the museum, by the museum, sponsored by the museum, of course, financed by the federal level and by the DZK, okay, but nevertheless, it is a question whether this is the best setup for provenance research. I would argue for a central unit that would somehow be linked to the arbitral court to support the arbitral court. This would not mean that any resources should be withdrawn from existing projects or decentralized units. Not at all. By no means. We do need the 2 levels of provenance research. the reactive level, reacting to claims, and the proactive level, doing a structural and systemic work on the level of the museums. Let me close this remark by one turn back to the Citroën case. I think the Citroën case shows very remarkably how important precise provenance research is, because if the provenance research may have been more precise in the sense that it would have been more informed on the legal level, it might not have addressed the wrong heirs. But because legally speaking, it is of course quite a simple thing that the ones that are not in the excluded as heirs in the will, these will not be those who have the claim. And nevertheless, I understand very well the disappointment by the Citroën children, who were approached, as far as I understand, proactively by the Dutch Central Unit on Provenance Research, and of course, then to be told, "Oh, we are sorry. You are, as opposed to what we said before, you are not the one who is entitled." That is something that should not happen, because it is part of the legacy of reacting to the Holocaust, to struggle with administrative bureaucratic systems. And that is a bad experience that should be avoided. All the more there is an importance to precise and legally informed provenance research that might be supported by a central unit. Thank you for giving me the time for this answer. And now the second part for the Netherlands. Thank you.
Let's see. Yeah, it works. So, Alfred, you asked about the decision in the Netherlands made where the research bureau from the RC was detached and placed at a different unit at the NIOD. Well, I think I always tend to look at things also historically, in the sense that the Dutch Restitution Committee, I think, suffered from a transparency issue, and that making a clear division between, on the one hand, the advisory work, and on the other hand, the provenance research, was to optimize those two different tasks. Because there have been claims where claimants, before that division, really questions whether the Restitutions Committee could advise objectively with the Research Bureau included at the Restitutions Committee. And I don't really think that there is a really big difference between how the provenance research is conducted before 2015 and after 2015. I think it's being done rather diligently. The provenance research is a very complex task, which takes time. As Matthias also mentioned, I think it is very important, in order to make a proper assessment and in order to return to, for example, the rightful owner, that you, for example, really exclude possible third parties. And I think, and that is also reflected in the Dutch policy documents, that also the Dutch ministry has acknowledged and pointed out to the fact that these claims over the years have become even more complex, simply because of the passage of time. And lastly, that when the Restitutions Committee started its work, it dealt with the most clear-cut cases that were based on the provenance research at that time, could lead to immediate restitutions. So I think that part of the delay, or the fact that the provenance research takes a long time, also relates to the complexity of the cases that has increased.
Thank you, Tabitha. Other questions in the classroom? No questions from the classroom. Are there questions in the video room?
I have a question. Can you hear me?
Brian, you opened the micro, is that right? No. Please
No.
feel
I did,
encouraged and
but somebody
invited,
else
but
speaking before
don't
me.
feel obliged. I cannot hear anyone at the moment. There is
Okay, so
faint
I have my
sound.
question.
I can't hear you. I need to do something here on the technology. Could you try it again?
Sorry, can you hear me now?
Yes.
Yes, we hear you now. Thank you.
Okay, thank you. And there was somebody else who I think tried to jump in also. Um, Maybe the name Zhen. I don't know how to pronounce it. Zhen. But I guess she could speak after me. But anyway, my question was um, if there were any parallels that could be drawn to non movable property. Forget aside from the cultural restitution, but property like land restitution. If you were aware of any movements or any processes or procedures that would allow somebody to make a claim in 2026 that due to new evidence should be reevaluated, similar to the cultural property.
Thank you for this question. That is a very relevant question, a question that is often raised, for example, in our class on the restitution of Nazi-looted cultural property. The question often comes up, why is all of this limited just to this class of assets, as opposed maybe to other classes of assets? The usual answer probably is that there was a special focus of the Nazi regime and its politics on art, that there was a specific remaining cluster of injustice and unjust enrichment in relation to movable property, in particular in relation to lost art. And that is why the Washington Principles on Nazi confiscated art were brought into existence. If that is a starting point that we are ready to accept, we, I think, need to accept that this particular instrument of soft law simply limits itself and its moral plea to this particular category of assets. So all the
But that's based on the terrorism declaration, isn't it? Meaning the Washington Principles is derivative of the terrorism declaration, in which the soft law applied to both property and cultural property, like movable and non-movable assets, right?
Yeah, you are right that the terrorism declaration broadened the scope and included immovable property. But I was trying to make the point that the implementation mechanisms that we see in the 5 and now including Switzerland 6 and maybe parts of Belgium 7 countries, the signatory states to the Washington Principles, restrict their implementing measures to this particular class of assets. And so I am not aware of any other mechanism that would be currently available to raise claims for restitution in the same way regarding immovable property. We've checked 1,300 cases from 6 jurisdictions. We didn't find one single case that at all touched upon the asset class of immovable property. That's the only thing I can contribute from my perspective as a kind of art lawyer and art restitutional scholar or researcher. And so I would say there are no ways open at the moment. Does that comply with the moral plea in the terrorism declaration? It depends on what happened after the war. And the understanding in Germany, and I would say also in other countries, is that the class of immovable property as a class of registered property was dealt with quite satisfactorily with the mechanisms that were set up by the military government law number 59 and its successor legislations by the German Federal Republic. But that would be, of course, a matter of evaluation, whether this is really satisfactory or whether there would be a moral need to go into this class of assets as well. That would be my reaction to your question. Maybe you wish to add to that from the perspective of the Netherlands.
I am going to, if you look back at the situation in the Netherlands around the establishment of the Dutch Restitutions Committee in the Netherlands around 1997, there was a discussion about the fate of Nazi-looted assets as a whole. And in the Netherlands, there were 5 advisory committees, if I am correct, that issued advisory reports on several categories of looted assets. And in the Netherlands, the choice was made to deal with that via financial compensation. And I think, and that is what I wrote about in my thesis, that the Netherlands, because of a fear of precedents, initially was not inclined to go on the down the road of a restitution policy on Nazi-looted art. So in the Netherlands, we dealt with other categories via financial compensation.
Yeah. Thank you, Tabitha. Does that answer the question as far as we are competent to answer it?
I think so. It just as a very quick follow-up, I know people are interested in other areas. Would you say that the change of the, let's say the world since 1997, or certainly since 1959, and 1997, and AI and all the abilities that you use for provenance research, would you say that using, let's say, an arbitral body to evaluate claims which may have been submitted and filed, several decades ago, but because of the limitations in technology and whatever else, were not properly adjudicated in a reasonable, or it turns out that the process was, not as thorough. Would you say that those should be revisited?
We discussed AI in the afternoon a lot in respect to provenance research, and we expect a huge effect of AI on provenance research in general. So I could imagine that there is an effect of provenance research driven by AI also on other asset classes. If that is something that materializes beyond a certain incidental, accidental, I should perhaps say, degree, then there would be a question how to deal with these new possibilities of establishing facts, information, and then we would need to reassess the state that we have achieved under the old restitution schemes. But I think I should also add that the idea of the post-war restitution schemes was to settle the cases and close them to allow a new economic order to a certain degree. We are not following this ratio in relation to the class of art and cultural objects under the Washington Principles, for example. So there might be leeway to extend this exception to immovable property as well. But we would also, I think, need to take into account in the principle of res judicata, there is a certain value and a certain element of justice as well. We would need to come to terms eating teleologies, I would say.
Thank you very much.
Thank you very much for very meaningful questions. There is Sen Shen.
Yes, thanks so much. I have 2 very brief questions. The first one is for Tabitha about the hardship clause. I wonder if you could elaborate on it a little bit more, like what is the criteria to prove a hardship? And the second one is for Matthias, because you mentioned the heirs can claim the property rights of Nazi-looted art, and also sometimes we need to consider the emotional and the spiritual connection. I wonder, are there any cases like the claimant also claim like mental damage compensation? or is that possible under German law? Thanks so much. Oh, I'm back.
So, Chen, we lost you technically. It must be the heat. You were asking in your second part a question in relation to emotional value. That's what I still gathered. Could you repeat the second part of your question, please?
Yes, I wonder, under German law, is that possible for the claimant to claim property right in the meanwhile, also for mental damage compensation, also for tort claims? Is this possible under German law? Thanks.
You start,
I will
answer.
start. Hi, Shen. Nice to see you again. Thanks for your interesting question. I must say that as far as criteria in order to be able to use the hardship clause, well, then you would have to look at the exact text, which basically states that there needs to be an exceptional case that presents compelling reasons to deviate from the assessment framework. And unfortunately, but maybe I missed something in reading the Constant report, there was no further explanation as to how it should be used. So, and then I look back, I take a step back and just look at the goal that has been stated by the Constant Committee, which is that the restitution policy needs to is an instrument in the goal of recognition. So whenever should there be so I think that should be the outline, the goal of recognition, and that a claim would present such special, extraordinary facts that there should not be any other solution than providing a just and fair solution. And what is clear is that the case of the Citroen recommendation does not present one.
Thank you, Peter. Then I must confine myself to very few words because we are being chucked out in a minute by the facility management for security reasons. So allow me to be very brief. I understood your question as going towards the German law on tort in relation to emotional values. And that is something that the German law offers: immaterial damage in certain constellations, in certain limited cases, however, not in relation to the damage of movable property, of chattels, so to speak. And it would be an interesting general question whether in German property law we are far too one-dimensional in that we just see the object, the physical object as such, rather than the object as an extension of the person's personality. And I think this is what we've experienced in the biggest intensity in the restitution field, that property is not just an object, it's not just the physical thing, that it's much more, and the emotional, the immaterial dimension of such objects is maybe the more important aspect of such objects, at least when it comes to undoing historical injustice.
Can I just interrupt very shortly? My name is Denise Citroen. Do you hear me?
Thank you for being here, Denise. Your question, also belonging to the Citroen family.
No, I just wanted, because you just mentioned the emotional worth of the objects. My case, as the granddaughter of the Citroen heritage, I must say I was very impressed by what you all said about our case. But unfortunately, the Restitution Committee is only half informed. They didn't take our timeline, our family history, and there are very omissions in their assumptions. And I would like to go in deep, not now, of course, but with Tabitha, I like to make an appointment and explain more about the Citroen case, because I have the feeling that today we were not really represented, and the Citroen case now is going into a direction, and that's not conform our experience and also our information, because the timeline wasn't in the advice from the Restitution Commission, and that's why there is a wrong image of what's going on. And I'm sorry that I'm so quick, because I know it's ending. My question is, Tabitha, would you like to meet with me and my sister to more go into the Citroen case?
Thank you, Denise, for intervening. This is very important to us. It's a controversial case, and I hand over perhaps to you to react, because you come from the jurisdiction and you are certainly more competent to comment on the overall situation, which is an unhappy one under all circumstances.
Thank you. I think to answer to go into your question immediately, if I would be willing to engage in a discussion, of course, because I think that I can only that it is interesting to learn about your specific perspective, and I think that we should leave it at that.
Okay. Then we continue.
Thank you very much.
Thank you very much for intervening. We'll continue the discussions here at other places. Thank you for intervening. Thank you all for intervening. Thank you for being here in these very difficult circumstances within the midst of a heat wave. We need to close right now in order to comply with fire police regulations. And I would like to thank you, above all, maybe special guest tonight, Tabitha Oost, but everyone in the room as well. Thank you very much for being here tonight. We do hope to see you soon again, and we'll continue our discussion, our dialogue, and our work. Thank you very much.